Our webinar today is called What is Section 503 of the Rehabilitation Act and How Can We Defend It? I'm going to just pause for about 30 seconds, just make sure everyone can join. And Allie's also shared the link to view captions separately if that's an effective method for you. Okay, next slide. Today's presenters are Jennifer Mathis, who is the Deputy Director of the Bauselin Center for Mental Health Law, and who has prior stints at the U.S. Equal Employment Opportunity Commission and the U.S. Department of Justice. You have me today, Claudia Center. I'm the Legal Director with Disability Rights Education and Defense Fund. And we're really hoping that we'll see Taryn McKenzie Williams, have her join us. She's tentative, and she can be available for supporting us during the question and answer. She's the former Assistant Secretary for Disability Employment Policy at the U.S. Department of Labor, which is a very important position for our topic today. Next slide. So I'm going to go through our agenda today. We're going to first talk about Section 503, kind of what it is and why we care about it. And we're going to talk about the 2013 Section 503 regulations. And Jennifer Mathis is going to be leading us through those slides. Then we're going to talk about what the new rulemaking, the proposed rulemaking from the Department of Labor says about the Section 503 regulations. And so it's the Department of Labor, but it's actually a subsection of that Department of Labor, which is called OFCCP, and we'll tell you what all that is. So we're going to explain what the rulemaking says. We're going to talk about why it's important that the rules stay in place and why the 2013 rules are important for equal employment opportunity. And then so that'll be Jennifer and me. Then we're going to talk about how to oppose the rescissions. We'll share with you some template comments that Dredif has written, which you can adapt for your own comment. And then we'll show you how to submit your comment on regulations.gov. And I'll lead us through that discussion. Then we'll have questions and answers, and that'll be me and Jennifer and hopefully Taryn. It's possible we'll end before an hour and a half, but we'll just see how it goes. So I'm going to say next slide and turn it over to Jennifer.
Hi, thank you, Claudia. Very happy to be here. And I am a white woman with short brown hair and glasses and a blue jacket. So Section 503 and the 2013 regulations is the title of this slide. 2013 was when the federal government, the Department of Labor, had updated its Section 503 implementing regulations for the first time in many, many years. Section 503 has been part of the Rehabilitation Act since the beginning, since 1973, and it applies to federal contractors and specifically to contractors with federal contracts of a certain size. And we'll talk about this. I just want to say at the outset that there are reasons why Section 503 is particularly important to people with disabilities. There are other disability discrimination laws that also apply to the same entities that Section 503 applies to. For example, Title I of the ADA applies to them as employers. But the importance of Section 503 is that it has affirmative action requirements that go beyond the non-discrimination requirements of the ADA, Section 504, other disability discrimination laws. And Section 503 applies to a workforce, the federal contractor workforce, that is very, very big, and essentially accounts for somewhere between 20 and 25% of the entire national workforce. So having Section 503's requirements applied to this very significant number of employees makes it a big deal. So uh, Section 503 in the statute applies, the law that Congress passed applies to contractors with contracts of at least $10,000. OFCCP, the Office of Federal Contract Compliance Programs, they have the duty to adjust that threshold periodically under another law, and so that has been adjusted to $15,000 if you have a contract of at least $15,000 with the Department of Labor, then you are covered. I'm sorry, with the federal government, you are contract covered by uh, Section 503. As we will talk about in the regulations, the affirmative action program requirements of Section 503 have been applied to contractors with larger federal contracts, so 50,000 or more and 50 or more employees. But we'll get to that. So Section 503 is enforced by the Department of Labor, by OFCCP. It's not enforced privately by individuals in court. It is enforced by the Department of Labor itself through compliance reviews, audits, through complaint process. People can file complaints with the Department of Labor alleging discrimination under Section 503 or otherwise violations of its requirements. And OFCCP can act in a number of ways, including litigating when they need to do that in an administrative process. But mostly they tend to work collaboratively with contractors to improve their affirmative action programs. If we can move to the next slide. Thank you. Okay, so the goal of Section 503 is really that Congress recognize that if the federal government is going to choose to contract with a particular entity, then they can choose to do it in a way that they think is appropriate. It's not a privilege. I'm sorry, it's a privilege, not a right to have a contract with the federal government. And so Congress said that, if we're going to have entities contracting with the federal government, they need to take affirmative steps, take affirmative action to employ in advance qualified people with disabilities in their workforces. So that is sort of the idea behind Section 503 of the Rehab Act. And it also requires some data collection about who's applying for federal contractor jobs and who is getting them, with the idea of measuring that progress toward the goals of affirmative action to employ and advance people with disabilities. Next slide. So, as I mentioned, in 2013, the federal government updated its Section 503 regulations for the first time in many, many years. We got there because there was a recognition that the existing regulations from the 1970s had not been terribly effective in ensuring that contractors were making progress in complying with Section 503 and doing affirmative action. And part of that was that there was no benchmark. There was nothing for contractors to measure their progress against. And so there was a pretty long process. This was a long rulemaking, began with an advance notice of proposed rulemaking in 2010 during the Obama administration. And the advance notice of proposed rulemaking asked a bunch of questions about what people thought that the Department of Labor should do to change to update the Section 503 regulations. That was followed by a proposed rule. There were a good number of comments. There were 400 comments on the proposed rule, not an extraordinary number of comments. There are rules that get a lot more, but this being a rule that is enforced only by the federal government, I think 400 comments was a significant amount of comments. There was certainly a lot of attention paid in the disability community and in the contractor community. And a lot of those comments actually reflected large groups of organizations together in the disability community. I remember there were, comments that were filed with dozens of organizations signing on. So 400 may not quite reflect the magnitude of the comments that were filed. And then the slide notes that the Department of Labor focused on for the reason for updating the Section 503 regulations, how poorly people with disabilities were faring in labor force participation. And this has been a historic trend that people with disabilities are underemployed and unemployed in large numbers. And typically, the labor force participation rate, I tend to use that as a little bit, um, I think it's a better benchmark than the unemployment rate, in that it takes into account people who have given up looking for a job, but are not in the labor force. So the labor force participation rate for people with disabilities tends to be around a third of the labor force participation rate for people without disabilities, somewhere between a third and a half, and it has hovered in that range for many, many years. So underemployment of people with disabilities has been a persistent problem, and Section 503, in part, is designed to address that problem. We can move to the next slide. So there were several things that the Department of Labor did in the 2013 regulations, but I'd like to focus first on the two most important things that it did. And one of those was for large federal contractors, that is contractors with 50 employees or more, and a contract of at least $50,000. The OFCCP updated its affirmative action requirements and imposed a benchmark, sometimes called a utilization goal of 7% for people with disabilities. And what that means is for each job group that a contractor has, and there are a set of job groups that OFCCP has. They include officials and managers, they include professionals, they include technicians, they include salespeople, they include office and clerical workers, they include skilled craft workers, etc. That gives you an idea of what a job group is. So for each job group, the regulation requires that or it imposes an aspirational goal for a contractor to have 7% of the workforce in each job group be people with disabilities. And for smaller federal contractors, which are contractors with 100 or fewer employees, they only have to meet a 7% benchmark for well, they don't have to meet it, but the aspirational goal is for their entire workforce as a whole, not job group by job group. But that is a very significant change in the rule. And that was critical to the rule because for the first time, it provided a benchmark against which progress could be measured. So when you're trying to understand if you are doing enough to meet affirmative action obligations, how do you know what is enough unless you have some sort of benchmark to measure yourself against? And OFCCP was very clear in the rule that a it is not a quota, the 7%. It is not a requirement that will put a contractor in violation of the law if the contractor isn't meeting it. but it is a benchmark. It is an aspirational goal, and it is a way to measure progress. So the second thing that OFCCP did that was very significant in this regulation was to include a new requirement that contractors invite applicants and invite employees if they choose to voluntarily self-identify as having a disability. And they have a form that people are supposed to get, the contractors use, that describes what it is to have a disability. Um, and lists examples. And that form, that invitation to self-identify is given to all applicants. It is separate from the job application. It can't be part of the application itself. Um, and it is given pre-offer before somebody gets a conditional job offer, and it is given post-offer after an applicant has gotten a conditional job offer. It is given to employees during their first year of employment and every 5 years after that. And the information from people who do choose to voluntarily self-identify as having a disability is kept in a separate file, not in people's personnel files. And so it's not going to like hiring managers. It is used for um, analysis of how much progress a contractor is making in meeting affirmative action goals. Next slide. So uh, some of the other things that are in the 2013 regulation are to go along with the benchmark, the 7% utilization goal, an analysis of how the contractor is doing, what kind of progress the employer is making. So what the contractor is supposed to do is every year supposed to do a self-analysis and look at whether they are meeting the 7% goal in each job group or for smaller contractors just across the workforce. And if they're not meeting the 7% goal, then they're supposed to identify what are the barriers that are preventing us from meeting those goals and what steps can we take to try to reach those goals and to make equal employment opportunity available. And they can look at things like modifying their personnel processes or doing more outreach and recruitment efforts. And those are that together is the analysis that a contractor is supposed to do every year. And so that gives you a sense of why the 7% goal is important, because there's something, that's the purpose of it. There's something for the contractor to measure against. If they're not meeting that goal, then they look at what the barriers are and how they can address them. Next slide. And I should say also that 7% was a fairly modest goal. There were the ADA Amendments Act had passed in intervening years and in 2008 and made clear that there's a Congress meant the definition of disability to be applied very broadly. And so given the percent of people with disabilities in the country, the numbers of people with disabilities in the country, 7% was a modest goal. It was based on census data with a calculation to try to account for people who were discouraged from seeking employment in the workforce, and determined that 7% should be the goal. Notably, we'll talk about this later, but the EEOC has a parallel regulation under Section 501 of the Rehab Act for federal agency employers, and they imposed a significantly higher goal of 12%. So 7% was certainly modest goal. OFCCP is supposed to have the ability to adjust it over time as needed. So Uh, this slide is about the elements of an affirmative action program. Um, Elements of an affirmative action program have been in the regulation for quite some time. The 2013 rule made some updates to it, but generally, an affirmative action program is supposed to include an equal opportunity statement that is from somebody high up in the company and the employer, evincing the commitment to affirmative action and expressing support for the affirmative action program, explaining people's rights against retaliation from taking certain actions, filing a complaint, etc., and explaining the non-discrimination and affirmative action requirements. So that has been in the rules for a long time. There is also a requirement that a contractor do periodic reviews of their personnel processes to avoid discrimination, avoid stereotypes, ensure accessibility, talks about encouraging contractors to have accessible information communication technology to provide needed reasonable accommodations, to avoid uh, qualification standards that tend to screen people out based on disability, et cetera. So all that's supposed to be part of the affirmative action program. And then appropriate outreach and recruitment activities are supposed to be part of the program. And the 2013 regulations made some updates there, and they had a long list of suggested activities that contractors can do to um, do outreach and recruitment for getting folks with disabilities to apply for federal contractor jobs, enlisting the help of vocational rehab, one stops, American Job Centers, VA regional offices, employment networks, independent living centers, etc. And one of the things that was added in 2013 to the regulation for affirmative action programs is having a data collection and analysis. So employers, contractors are supposed to record the number of applicants they had, total the number of those applicants who had disabilities, at least who identified voluntarily as such, the number of job openings and jobs filled, and the total number of applicants that were hired, and those who were hired who had disabilities. And so that data collection enables an analysis, enables a look at sort of what kind of progress is being made overall. Are you uh, taking a pool of applicants with a large number of disabilities and hiring a very small number of disabilities overall, or vice versa? So that is part of the affirmative action plan. And then I think I have one more slide. Um, if we can, yes. We have in here a couple of quotes. One is a very old quote: when you can measure what you're speaking about and express it in numbers, you know something about it. And then that was from Lord Kelvin in 1889, but then from Pat Shue, who was the director of OFCCP at the time that the regulation was adopted in 2013 or updated. What gets measured gets done. And that is to say that if we don't have a benchmark, we don't have a way to look at what is being done and what progress there is, and contractors don't have any guide for what to do if they don't know what they're aiming for. So that is why OFCCP put in a measurement and put in some data collection requirements to ensure that there was a useful analysis that was done to look at progress being made. And now I'm going to turn it back over to Claudia to talk about the impact of the 503 rule in 2013.
Thank you. Next slide. So we're going to talk a little bit about the impact of the 2013 regulations that Jennifer just reviewed. Next slide. One of the things that's a little tricky about contractor workforce data is that these are private companies, so their workforce data is not subject typically to any kind of Public Record Act requests or FOIA requests. So it's not transparent exactly what the workforce data is at this time. So we have to look at what researchers have found through their own surveys and through consultations with OFCCP about those compliance reviews that Jennifer mentioned before. There are periodic compliance reviews that OFCCP does, but because there are so many contractors, estimated 200,000, those are only going to be a small percentage of federal contractors. But what we do see is a very well-designed survey by Cornell University, and some of you may know Cornell has a expertise in employment research. And so Cornell did a survey in 2017 of more than 200 federal contractors, and they found that most of the contractors had changed their affirmative action goals in response to the regulations, and that large majorities reported that they are using or planning to use their this data collection, as a way to measure their progress towards the 7% utilization goal, to assess their outreach and recruitment, to assess their progress in hiring, in retention, and in advancement. So we don't have clear outcomes yet about actual improvements in the percentage of people with disabilities in the workforce, but we do know that large majorities of contractors, as of 2017, which was when those rules were very young in the history of the rules, had already made a lot of changes to their internal approach. So that was a positive. At that time, the contractors surveyed, only 15% said that they had already reached the 7% goal. And we just don't know in the 8 years since then what the numbers look like. Next slide. We do know from an NCD report, the NCD reached out to the OFCCP, the National Council on Disability, lots of acronyms, and looked at some of the data that OFCCP could provide. We do know that between 2015 and 2020, contractors subject to the OFCCP reported over 10,000 hires of people with disabilities. Again, we think this is probably the small percentage of people who were interacting with OFCCP through a compliance review or through another method. We also know that over a little less than 2 years, the number of federal contractors that reported to OFCCP that they had met the 7% increased substantially. We don't exactly know the denominator for these numbers, but we believe that it's probably related to those periodic compliance reviews. So I'm going to turn it back to Jennifer, next slide, who's going to talk a little bit about the federal government experience, which is, we believe, an analogous example.
Thanks, Claudia. So, as I mentioned before, the Equal Employment Opportunity Commission, or EEOC, has issued parallel regulations under Section 501 of the Rehabilitation Act. And like Section 503, Section 501 has an affirmative action requirement as well. And so several years after DOL, the Department of Labor, issued its updated Section 503 rule, the EEOC issued its own Section 501 update to those rules. And they actually they followed the approach of the Department of Labor in setting a benchmark. So they set the benchmark for affirmative action obligations for federal agencies, and 501 applies to federal agencies, federal executive branch agencies. And it also requires affirmative action in employing and advancing people with disabilities. So they set the benchmark at 12% of the workforce for federal agencies. And they also set what is sometimes called a sub-goal, um, specifically for people with targeted disabilities. And that is a separate list, which is primarily people with the types of disabilities where people have been historically excluded from the workforce in particularly large numbers, people with intellectual disabilities, people who are deaf, people who are blind or low vision. And there's a list of targeted disabilities. So in addition to setting a 12% benchmark for the people with disabilities generally, EEOC set a separate 2% benchmark for people with that specific set of targeted disabilities. And what they found when they collected data is within a couple of years, those benchmarks seem to make a significant difference. There was a goal that was set by an executive order at the time of having the federal government hire 100,000 people with disabilities. Between 2011 and 2015, the federal government exceeded that goal, hired 143,600 people with disabilities. And during 2016 to 2018, shortly after the regulation was promulgated in 2017, was issued, the federal government was meeting, on average, was meeting that goal of 12%. And by 2018, where they were also on average meeting the 2% goal for people with targeted disabilities. Not every agency was meeting those goals, but across the average of the federal government, those goals were met, showing that certainly compared to the 7% modest goal set by the Labor Department for federal contractors, it was doable to hire people with disabilities at a rate that was sufficient that they would meet a 12% goal across the federal government. And I'm going to turn it back over to Claudia.
Thank you. Next slide. Okay, so now we're going to talk about the proposed rescissions to the Section 503 regulations. Next slide. So this is probably unsurprising, but basically all of the strengthenings of the Section 503 regulations that Jennifer just reviewed are proposed to be deleted. So all references to the 7% goal or benchmark for the employment of people with disabilities is proposed to be deleted. The agency proposes to delete all references to the invitation to self-identify as a person with a disability. It proposes to delete all references to the data collection related to people with disabilities, and it proposes to delete all references to the analysis of the data collected about people with disabilities, that comparison to the 7% benchmark, and the idea of identifying problem areas and coming up with an action-oriented response to try and address those problem areas. So really just deleting everything that we just talked about that was added in 2013. There's also a long passage in the proposal that adds procedural regulations for the Department of Labor to follow in Section 503 matters, including complaints. And the reason that exists there is because the DOL proposes to delete all of the existing procedures that cover um, all types of issues around race, sex, and disability. So they're deleting the existing procedures related to the administration's executive order rescinding, I know this is so confusing, rescinding President Johnson's 1964 era Executive Order 11246. So basically, after the Civil Rights Act of 1964, President Johnson issued an executive order um, directing certain steps, including for federal contractors, to ensure equal employment opportunity based on race and then based on sex, and then the regulations added disability. Those regulations are now proposed to be deleted. So because Section 503 is in the US Code, the Department of Labor can't delete it, but they are moving the procedural regulations essentially into a special section just for 503. Next slide. Okay, so how to oppose the proposed, this is a tongue twister, how to defend Section 503 and how to submit a comment that opposes the proposed rules that would rescind these important provisions. Next slide. Okay, so first step is you have to know the deadline. The deadline is Tuesday, September 2, 2025 at 11:59 p.m. Eastern Time, 8:59 p.m. Pacific Time. So you want to make sure you know the deadline and make a plan for submitting your comment. So that's really important because they shut off the portal right at that time. So you got to make sure you build in time to submit your comment. Second, you want to write your comment to the OFCCP about the Section 503 rules. The most important thing is for you to kind of tell OFCCP a little bit about yourself or a little bit about your organization or both, and to say why you care about the employment of people with disabilities and why you care about affirmative action for people with disabilities in employment. You want to say why OFCCP should not get rid of all of the rules about looking at the data and making a plan to reach the 7% goal. Allie's going to put in some links in the chat to some template letters that Dredif has written that you can download and edit to make your own. There's one that is in sort of standard English, and then there's one that's in plainer English, plainer language. Um, as usually happens, the plainer language one always seems better to me once we have both versions. And you can download these and edit them and make them your own. By around tomorrow, we'll have all of these up on our website, along with the video for this webinar. So, but if you're feeling like you want to jump on this today, we are including the links in the chat. And again, the most important part is to tell OFCCP some details about yourself and your organization and say why you care about the employment of people with disabilities by federal contractors. And as Jennifer said, that's 25% of our workforce. And you want to try and edit it as much as possible because we hear that they're trying to look at comments and disregard comments that they think are template comments. So try and individualize it if you can. And next slide. Okay, so now we're going to show you how the regulations.gov portal works. So the third step of opposing these changes is to file your comment online. So you're going to go to this link on regulations.gov, and this link is called Modifications to the Regulations Implementing Section 503 of the Rehabilitation Act. If for some reason you lose access to our slides and you can't find the link, just go to regulations.gov and type 503 into the search bar and it'll pop up. So then you're going to want to select that blue comment button. It's a blue rectangle. It says comment in the image on this slide. It's on the left side about 2/3 of the way up, so kind of toward the top. It's a blue rectangle that says comment. So you're going to click on that. Next slide. So the next screen is going to start at the beginning to say you are commenting on a rule by the Office of Federal Contract Compliance Program. So that's the long name for OFCCP. And so the first field just says comment. It's a required field. So you can write your comment right in that comment box if you want to. That might be the easiest for you. To fit, your comment has to be less than 5,000 characters. Right now, our plainer language template is way below 5,000 characters. Our standard language comment template is not. But if you are able to stay within 5,000 characters, I'm pretty sure it includes spaces. You can write it right in that comment box. Next slide. You can also write your comments in a document, like a Word document or a PDF file. And so if you do this, the document can be as long as you want. It can be longer than 5,000 characters. Then you have to attach the file with your comments. So the comment field, which you can see in this picture, the comment field has a star next to it, meaning it's a required field. So you have to write something in there like see attached file. And then you're gonna basically upload your comment file in the next field, which says attach files. Next slide. So assuming now you've either attached your file with your comments, or you've written your comments in that 5,000 character field. And now you have to fill out the rest of the fields. So that includes your name, your email address, that's optional, whether you are an individual, organization, or anonymous. So here we've shown it with the organization highlighted as though the commenter is selected organization. If you're filing for an organization, there's a drop-down menu for your organization type. In this picture, we've selected organization, which is kind of a funny pull down for organization type, and then you type in the organization name. Next slide. So this slide shows what the portal looks like if you select individual. And if you select individual, you fill in your first and last name. And then optionally, you fill in city, state, zip code, country, and phone number. Those are optional. Next slide. Then there's a reCAPTCHA that's required where you click on the button to say you're not a robot, and then you click on the blue submit comment button. Next slide. So I know it can be a challenging time to be someone who cares about the rights of our communities. And we want to reinforce that we all still have rights under our statutes. The OFCCP cannot change the statutes enacted by Congress and by our state legislatures. We can still watch out for and complain about disability discrimination by federal contractors, We can still ask for accommodations at work. We can still file discrimination complaints with federal agencies, with state agencies. We can still file cases in state or federal courts. We can still consult an attorney to assist us with any of these. Next slide. We can make our voices heard. Jennifer talked about how in the 2013 comment cycle, there were 400 comments. I'm hoping that we exceed this by, several factors if possible. I looked this morning and there's already 144 comments submitted. But I'd love us to have many more to show the administration, including the Department of Labor, that the disability community is watching and that we care about equal employment opportunity for people with disabilities. Next slide. Okay, this is a slide that says nothing about us without us, a photo by Disabled in Here. With a picture of a bearded Black man wearing glasses, overalls, with a sign that says nothing about us without us. And of course, that's an important principle of the disability rights movement and many other rights movements. Next slide. Okay, we're now at the question and answer period. We have plenty of time for questions and answers. We also have Taryn who's joined us, who can type answers in the Q&A. So I know I saw one in the chat, so I'm going to read it out loud. And I will ask either Jennifer to answer it, because I don't know the answer, or for Taryn to type it in the chat, and then I'll read it out loud. Okay, here's the question. Several federal agencies count hires under targeted and non-targeted in both categories, i.e. I am an individual with a targeted disability, and I am a person with a disability, therefore I'm counted twice. As to the goal of 100,000, the federal government counted not only new hires, i.e. the person who never worked in the government, they also counted the federal employee who moved from one agency to another agency. Therefore, it was not a true statistic. It was to be 100,000 new hires, not 100,000 mix of new hires and moving from the agency to agency. That statistic is very skewed. Jennifer, do you know about that one?
Yeah, so I would just say, I mean, that may be there are issues with, how EEOC counts and how OFCCP counts. But I think our point in highlighting what happened with the EEOC's parallel rule under Section 501 was really just to show that having a benchmark can make a difference, and that it really seemed to make a significant difference under Section 501. There's much more publicly available data under Section 501 than there is under Section 503, which is why, in addition to looking at the little tiny bits of data that we could find about what happened with the 503 benchmark and what the impact of it was, we can also, I think, draw some inferences from what happened with the parallel benchmarks under Section 501, and that they made a difference. And that's really our point. Yes, there may be, I think, some things that are imperfections and problems with, how data is counted generally, but that was really the point.
Thanks, Jennifer. Here's another question that's in our Q&A box. How will a federal agency obtain disability information without violating an employee's right to confidentiality and the right not to self-report? Even asking someone to self-identify seems to put employees in a difficult position and intimidation to answer if the question comes up in the application process. Are the agencies going to mainly rely on accommodation requests to identify individuals with disabilities working for the agency. So I don't know, Jennifer, if you want to, well, this is about federal agency, but I assume they also mean federal contractor. Jennifer, if you want to start and then,
Yeah.
yeah.
Uh, So that's a great question. I saw it in the chat and I thought it was better to answer it just live because it's an important question that's complicated and contractors raised this issue um, with the original with the 503 rulemaking in 2013 and said, hey, um, how can you require us to invite people to self-identify as having a disability when the ADA says, particularly before you've given anybody a conditional job offer, um, when the ADA says that you can't ask people uh, anything that would elicit information about a disability. You can't ask people whether they have a disability before you've given them a conditional job offer. And so, aren't we violating the EDA if we do that? And at that time, the Labor Department put into the rulemaking um, an explanation of why it did not violate the ADA to do that. And they had actually an opinion letter from the EEOC explaining the EEOC's longstanding position over many years, which was in its regulations and in its guidance. And it basically explained, it was from the EEOC's legal counsel at the time, Peggy Mastriani, been there for many, many years. And it explained that number one, the EEOC's ADA regulations have always provided that employers are not liable for a violation of the ADA for an action that is required by another federal law or another federal regulation. And in fact, the regulations in their appendix actually talked about Section 503. It talked about how, of course, um, if contractors were required by Section 503 to ask people to invite people to self-identify, that they would not be violating the ADA by doing that. So there's specific discussion about that in the EEOC's regulations, and then also the EEOC had said it is it's in our guidance that we interpret the ADA to not prohibit pre-employment questions about disability if it's part of a voluntary affirmative action program. And then finally, the EEOC said that it has always been part of the EEOC regulations that um, employers can comply with another law that affords people with disabilities equal or greater rights. And so if Section 503 affords people greater rights by having an affirmative action program, then it wouldn't violate the ADA to have a contractor do what the Section 503 regulation did. So that is basically the explanation. Currently, the Department of Labor is saying, well, we don't agree with that anymore. And that was just one person at the EEOC at that time. It was a long time ago. It was more than 10 years ago. I would just say it wasn't just a random person. It was the EEOC's legal counsel who had been there for decades and basically played a leading role in every part of that agency and was the EEOC's longstanding position in its regulations, in its guidance, and there were multiple rationales. And so for the Department of Labor now to say this was just some random person at some random time seems a little disingenuous.
This is Claudia. I'm just going to read some items in the chat. We will get to everyone's questions and either in the Q&A or in the chat. But I'm going to focus on the ones right now that are about the disability inquiries. from one of our attendees writes, the NPRM says inviting disability disclosure violates the pre-employment inquiry of the ADA. This doesn't seem right. Have there been any court decisions addressing this issue? I don't know, Jennifer, if you want to talk about the contractors versus shoe case, or maybe Taryn wants to type about that.
Yeah, and I don't, well, the contractors versus shoe case um, was, I thought, more about just a challenge to the benchmark, right? Because the contractors trade association, ABC, I think Associated Builders and Contractors, argued that they challenged the 7% utilization goal, saying that they didn't think that people with disabilities could do construction jobs. I'm sorry, I shouldn't have said Contractors Trade Association. I meant to say Construction Contractors Trade Association. um, they said these jobs are particularly dangerous and difficult, and so we don't think that it's fair to hold us to a benchmark for people with disabilities when we don't think they could do these jobs. There's a lot of evidence in that case that very similar jobs were done by people with disabilities in the federal government successfully, and so the court ended up rejecting that challenge. But as to the question about, again, pre-employment inquiries, that is what we just talked about with EEOC making very clear in 2013 why inviting contractors, I'm sorry, inviting job applicants to voluntarily self-identify does not violate the ADA, and the EEOC was the agency charged with enforcing and implementing that part of the ADA, and they were very clear over many, many years that it would not violate the ADA to invite somebody to self-identify as part of a voluntary affirmative action program, including Section 503.
And Jennifer, do you want to, I should have done this before, but do you want to tell people what's a pre-offer inquiry and what's post-offer?
Yeah, so sorry, it's a little bit complicated, but under the ADA, there's sort of a two-part process in job applications. Designed so that there is confidentiality, there is privacy, that if you have a disability, the employer is during this pre-offer phase, before they give you a conditional job offer, saying you're hired subject to X, Y, and Z, um, they cannot ask about a person's disability generally. And there are exceptions, including what we just talked about. But generally, during that process, they can't ask about disability. Before they give you a conditional job offer, they can ask you if you can do the essential functions of the job, but they can't say, do you have a disability that will prevent you from doing that? But then after they give you a conditional job offer, then the employer can ask about disability. At that point, they can't deny you a job based on your disability unless they can show that it means you can't do the job. It means you can't do the essential functions of the job. But having that process split up into two parts enables people to then know if it was their disability that was the reason they didn't get the job. And so that is what the pre-offer and post-offer phases are for federal contractors. They still have to do that pre and post-offer thing and give people a conditional job offer, but they are allowed, unlike most employers, if they're covered by Section 503, they are allowed to do that invitation to voluntarily self-identify.
And there are two other legal principles, this is Claudia, that I might mention. There is the principle that inquiries about disability are permitted if they're job related and consistent with business necessity. So that is one way that, the employer could say, well, we need this, we need to make these inquiries due to our affirmative action plan. It's necessary and it's voluntary, so you don't have to answer if you don't want to. There's also a case that the AARP brought when the EEOC adopted wellness regulations that the disability community hated. These were regulations that allowed workplaces to offer wellness programs that included sort of big deductions or denial of deductions in your healthcare costs based on things like, weight loss or blood pressure, or did you do preventative health care and so on. And so the court, I think it was the DC District Court, ruled that um, the regulations encompassed practices that weren't voluntary because the monetary and other costs were so great to the employees. So this is quite different from that in that, it really is just, you can either fill it out or you don't have to fill it out. There's no requirement to fill out the form. Um, I mean, it's a little more complicated than that, but I just wanted to cite those two um, legal principles. There's another comment about the confidentiality question that says the federal government can require you to complete SF 256 if you are hired under Schedule A, and so then there's a citation for Schedule A, or if you are hired competitively yet are requesting a reasonable accommodation. All documents should be held only by the agency's EEO and HR departments. So I think I'll let Jennifer or Taryn add, but I think that's just saying that this is a common practice with the federal government.
Yeah, and right, there's an applicant flow form, and there's a SF-256 is where you self-identify as having a disability for 501 purposes. So it's very similar. The idea is that you in the federal government also have a voluntary affirmative action program. And so ADA doesn't apply to the federal government, but Section 504 and 501 do. And you can ask pre-offer for purposes of voluntary affirmative action under Section 501.
Thanks. Okay, so there's another question about 503, which says, under 503 federal contractors, what monitoring, if any, is done to ensure that the contractor is not double dipping by counting a disabled veteran in two categories, basically disabled veteran and individual with a disability. Then it says under the Schedule A hiring authority, the regulation still mandates the person to be under a mandatory 2-year probationary period. Sorry, I just lost my place. Whereas a 30% or greater disabled veteran who may be hired for the exact same job series and grade, as well as the same federal agency, can be converted after one full pay period. It seems like more than one question, but I don't know the details of the veterans affirmative action.
Yeah, the Veterans Affirmative Action program is under VEVRA, the Vietnam Era Veterans Something and Something Act, a Reauthorization Act. But I don't know whether contractors or employers can count somebody toward both goals, both the VEVRA benchmark as well as the 503 benchmark. But I would just say, I mean, they're kind of separate obligations. So even if they did count the same person twice, they do have an obligation under this law and they have an obligation under that law. But regardless of that, people should comment on the 503 rules and the proposed deletion.
And I'm going to read Taryn's additions to these. As far as I know, there's no rule against counting a disabled veteran in both categories, but and Jennifer's nodding her head in agreement. Taryn also writes, it's correct that federal agencies commonly do collect all these data. And yes, the probationary period is different for Schedule A, and I think that means compared to the veterans pathway, and has been subject to criticism because of the 2-year period. Um, okay, our next question is, will the proposed amendments affect the availability of disparate impact disability discrimination theories?
And that's an interesting question. Disparate impact, disability discrimination, obviously, um, depends on, or proving such a claim depends on having data about the numbers of people with disabilities that are affected by a policy, and the more data that there is about people with disabilities in the workforce, I think the more useful. Um, I think it's a hard question. I think in the abstract, it may depend on what kind of disparate impact claim it would be, but generally, I think it is easier the more data that you have, and certainly with less data, because there would be no more invitation for people to self-identify. It is probably harder.
And this is Claudia. I'll just add, so in the context of disparate impact claims for under ADA laws, there is not a requirement that disability statistics be provided. There's not a requirement that there be a statistical analysis such as you would have under Title VII, for example, related to sex or race discrimination. And there's a number of reasons for that. One of those reasons is that sometimes disparate impact discrimination happens and the causation can be proved in a more mechanical way than for when you're proving it with a more indirect causation. So for example, um, if the if the employment practice is that everybody who drives a package van, and this is the UPS versus Bates fact pattern, has to pass a hearing test, um, you don't have to have statistics about how many hard of hearing people or deaf people fail the hearing test, because it's obviously sort of mechanically screening out people who are deaf and hard of hearing. So the causation can be really different in disability context. So you're not always providing disability data in disparate impact cases brought under disability rules, laws. But yes, if you were doing an employment disparate impact case with a federal contractor, it's certainly very useful to be able to, in discovery, request all of those forms. I mean, they have to be redacted, but all of those forms to see what you find out from that data. So just wanted to add a little more nuance to that question. Let me just check and make sure that, okay, nothing more from Taryn. Okay, we answered that live. Um, is any of the data OFCCP collected over the years available? And if so, where do we find it?
That's a good question, Ken. Most of it is not available. We have been working very hard to try to find whatever is available. I think there is some information available through second-hand sources. So there is a National Council on Disability report that has a little bit of information in it that is useful. I don't know if we can send these links to people, maybe. There's a study that was done of the impact of Section 503 rules that has some information And there's not a whole lot of other stuff that we found.
Yes, we can put links on our when we post the video for this website, we can post the links. Some of the links are in the longer template letter, but not all of them. Um, yeah, it's not transparent. Like not that the federal government is completely transparent, but that data is much more um, accessible for researchers. Um, and then Taryn writes, a great question. Most data are not available despite efforts from agencies and advocates to compel OFCCP to release it. Yes, very true. And I know that the Cornell research, and there were 2 or 3 reports that came out of that research that was done kind of between 2017 and 2020, they were able to convince OFCCP to share some information with them, but it was quite limited. Um, Anything more to say to Ken's question?
I would just say that is why, we talked about the experience with Section 501 and the parallel um, benchmarks that are used in those rules, the impact that they had, because I think to some extent, given that there is much more information available about Section 501, one can infer some things from that. And so, it's not like the federal contractor workforce is exceedingly different from the federal agency workforce. In fact, that construction contractors case showed that they were not. The same types of jobs exist in both workforces. So I think that sometimes the best we can do is to extrapolate from something parallel, and we have to do some of that here.
And then the last question, I think, is what is the most persuasive response to DOL's argument that the utilization goals, especially for job groups, no longer apply due to the rescission of the earlier EO? I think that probably means the President Johnson era EO. Um, I'll start and answer. I think that the 2013 rulemaking made clear that they wanted the larger contractors with more than 100 employees to um, analyze the 7% benchmark against job groups because that's really the most effective way to understand whether you're making progress in hiring, retention, and promotion is to look at job groups. If you just look across your company, you could be missing a great deal of many gaps in employment. Um, Jennifer?
Yeah, and I mean the fact that Section 11246, or rather Executive Order 11246 was rescinded, um, you know, and therefore the job groups were rescinded. I mean, that doesn't impact Section 503 in the sense that Section 503's analysis could continue regardless. It's a statute, it's not an executive order. It can't be rescinded by the president. The rule can change, but one could still do the job groups analysis with those job groups. Those job groups were just made up by OFCCP, as I understand it.
There was one more request for a citation for the ABC versus Shoe case, which I've put in the chat. Can't remember if it's in the NPRM or not, but in any event, it's in the chat for people who want it. Well, as promised, we did not take the full hour and a half, or as not promised, but as suggested might happen. I really thank you for your attention and your good questions. I really hope that we have a robust showing in this comment period. I really do think that our participation, even if it can feel um, challenging right now, I think our participation can matter. They know that we're watching, that we're participating, that we're opposing what they're doing. Please reach out to me and I'll make sure that you get any resource you need to file comments or to share the comment opportunity with other people. We should be posting this webinar tomorrow, maybe Thursday morning, and we'll have up there all the templates and the other links that we talked about today. Um, so so onward, we got to stay together. Jennifer, any closing words from you?
Please submit comments. It's important. Exercise your rights to be part of the rulemaking process.
If we all submit comments and get one other group to submit comments, we'll have way more comments. So thank you. Oh, and Taryn writes, please make your voices heard. It does matter. Thank you, Taryn. All right, I think we're done. Allie, you can shut us down.